What's going on, everybody? Welcome in. It's Sunday night here on Let's Talk Live on the LTL Media channel. How's everybody's weekend going so far? It's nice to see everybody come over into the chat and super casual, laid back show tonight. I thought that it would be a good idea because there's a lot of people that have just, maybe found Karen Read's case over the last couple of months, over the last couple of weeks, last couple of days. And they might be wondering, how did we all get here? What I wanted to do tonight was go back to Karen Read's arraignment. A lot of people haven't even heard that. And it's funny, I've played clips of it before and they're like, I haven't even seen this yet. So I want to go back to Karen Read's arraignment, how this case all started with her initial charges. And then I want to play a very important hearing that happened almost a year ago, probably just a little over a year ago on May 3rd, which was a very, very compelling hearing where we saw the first time Alan Jackson show the actual dog bites and scratches on John O'Keefe's arm. And it was pretty shocking. It was pretty shocking to see that. And, I just thought that it would be really great to do those hearings because people haven't seen them. So we know that we're getting ready to go back into court for another hearing on the 22nd. We know all the things that have come up. It's funny, I looked at July 1st and I said, we're probably not going to hear anything anymore about this case until the 22nd. And literally, we hear news every single day. So I thought this would be a good time just to go back for new viewers or even old viewers to go back and review things. And, we'll go through that tonight. I want to let everybody know tonight that I'm going to do my customary, any donations that come in tonight, 25% of your donation will get donated to Karen Read's Defense Fund. I like to try to at least get to $50 to put that up on the board. And then what I do is I'll post it on her Defense Fund page, and I'll just put LTL chat raiser, LTL media chat raiser, and then the date of 7/14/24. So we'll get that up there. And what else? I have an announcement that I want to let everybody know. I'm going to pull that up in a second. I had something else that I wanted to say, and it totally just escaped my mind. I don't know. I forgot. But anyway, we'll pull this up. So tomorrow, I want to let everybody know that there is a standout at Norfolk District Attorney's Office, Michael Morrissey's office at 45 Shawmont Ave in Canton, Massachusetts, from 3 to 6 p.m. This will be a peaceful protest. And Paul Christopher asked me if I could talk about this on my show. Of course. So if you are a local and you can make it out there tomorrow from 3 to 6 p.m., it would be really great for you to get out there and help support Karen. I'll just read this really quick. In the light of recent filings in the Karen Read case regarding the jury and recent suspensions of the state police officer Michael Proctor, who has close personal relationships with witnesses in the case, and the Canton police officer Kevin Albert, brother of Brian and Chris Albert, both witnesses in this case. DA Morrissey needs to do the right thing and drop everything that's going forward. We have a perfect example this week how a prosecutor's office should be handled after misconduct in the investigation of Alec Baldwin. The judge took action due to the conduct and prosecution in that case. Michael Morrissey's office should avoid the same results and not push forward with the Read case and reinvestigation the death of Boston police officer John O'Keefe. So if you can make it out there tomorrow, so tomorrow at DA Michael Morrissey's office, 45 Shawmont Road in Canton, Mass., and that's going to be from 3 to 6 p.m. So if you can make that and you're local, we'd love to see you over there. I wish I could make it. I cannot. I have to work, so I will be there in spirit and in support, and I hope that they get a lot of people that can show up for that tomorrow. So good stuff. And, look, tomorrow, yesterday we had, a pretty crazy day in American history. I'm not going to really rehash too much of that content. But obviously yesterday was, in my opinion, a very sad day for America. And I just want to make this really, really clear to everybody. Okay. I had made a post about talking about this is not the way that you win elections. And I think some people took it in the fashion that I was saying that, this was a Democrat that did it. I didn't mean that at all. I didn't mean it in that way at all. What I'm basically saying here is that this is not the right way to win elections. There should be no political violence against any political candidate in this country. It's not going to solve anything. I would be reporting on it if it was Joe Biden. I'd be reporting on it, Donald Trump, Obama, whoever's the president at that time. I looked at the sense of this is a big day in American history. It's very odd to me, just looking at the content that was brought across the YouTube spectrum. And even today, when I was out, no one even talking about this. This is huge. It's big news. And I don't want to see this happen to any political candidate. That's why we put this system in place. This is why we've put the system in place for the public to go to the polls and vote for the person they want to run this country every 4 years. And it's important to keep that. We don't want people suppressing political views or politics. We have every right to do that in this country. So whatever, side of the aisle you stand on, it's just not a good thing for America overall. So I don't want to keep going into it that much. I don't want to make this a political stream. I just wanted to talk about my point of view. I essentially just wanted to report the news yesterday. It was a very big day in American history. There was a man that actually lost his life that was protecting his family, and that's awful. And my heart goes out to his family. And I think there was a few people that were injured. Believe me, there will be a lot of investigation about this and more news that will come out. Let's just wait until we get the conclusion on that. And everybody in the chat has their own personal thoughts and their rights to that, and have at it. I'm going to wait and listen a little bit more, research, find out what happened. And I really don't think this will be too much more of that content that I will put up here. But if there's any type of breaking news like that, it is very important to report it. So anyway, I digress on that subject. I just wanted to make it clear where I was coming from. I'm not going to banter back and forth. I understand that there's people from all political walks of life that watch this channel, and I was just basically reporting. So anyway, so we will get into tonight's live. So let's do this. Let's go to the first arraignment in Karen Read. If you haven't heard this, this would be a great opportunity. And we will play through this. I'm going to say the audio is pretty bad. I'm going to boost it as much as I can. And we'll get going here. So let's do this. Here we go.
Homicide by negligent operation of a motor vehicle.
Hopefully the audio is good.
Personal injury and death. These offenses taken place January 29, 2022 in the town of Canton.
Good morning, ma'am. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violate a release condition while this case is pending, you could be held in the House of Correction for up to 90 days without bail. Good morning, Mr. Netti. Good morning, Mr. Lally.
Good morning, Ron.
All right. Mr. Lally.
Your Honor, with the court's permission, could I just pull the mask?
Yes. Yes.
Thank you, Your Honor. Your Honor, Adam Lally for the Commonwealth. The Commonwealth is requesting that the court set a cash bail in this matter in the amount of $50,000 with some additional conditions. Those conditions being the bail warnings that's just read by Your Honor to the defendant, as well as conditions that she stay away and have no contact with the deceased victim's family, that she stay away and have no contact with the deceased victim's residence, and that she be prohibited from operating a motor vehicle during the pendency of this case. In support of that request, Your Honor, the Commonwealth would cite the nature and circumstances of the offense, as well as the potential penalty that the defendant faces, particularly with reference to the manslaughter charge and the leaving the scene of personal injury and death, the latter.
So this is pre-second degree murder charge. This is the first arraignment. So she was only facing manslaughter and leaving the scene. Manslaughter while intoxicated and leaving the scene. The second degree murder charge hadn't even put forward yet. And I think they brought Karen in. They threw these charges at her. They probably tried to negotiate something like, hey, if you want to take a deal. She said, nope, I'm going to get the highest powered attorneys that I can find to represent me. And then what did they do? They came back and slapped the second degree murder and all those undercharges on her.
Are being combined over. The facts of this case, Your Honor, essentially on this past Friday into Saturday, January 29th, at approximately 6:04 a.m., the Canton Police Department received a 911 call from a woman reporting a male party subsequently identified as the decedent and victim, Mr. John O'Keefe, who was found in the snow at a residence on Fairview Road. At the time of the 911 call, there was heavy snow and the temperature was in the teens. Officers Saraf and Mullaney of the Canton Police were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first to arrive on scene and observed three females waving at him. If you were standing on the roadway looking at the property, the three females were in the left corner of that property. Officer Saraf observed the victim lying on the ground as two of the females were performing CPR. The three females on scene were subsequently identified as the defendant before you, Ms. Karen Reed, Ms. Jennifer McCabe, and Ms. Kerry Roberts. Officer Saraf observed the victim to be cold to the touch, no signs of breath, and returned to his cruiser to retrieve his AED device. This time, Canton Fire and EMS.
Bukaki is next, $10. Thank you for kicking it off. 25% of your donation will go to Karen Reed's Defense Fund. And I think when we came in, we had a new member too. So let's add $5 also. Let me go back up. So I think we're at 15. Linda, thank you for becoming a new member. So we'll round that up to $5. And we're at 15 right now. If one of my moderators can just keep track of that, it'd be great. And then we'll get this going. Hopefully we get some rolling and make some money for Karen tonight and kick back to that defense fund. All right.
EMS arrived on scene and took over first aid. Paramedics then transported the victim to the Good Samaritan Hospital in Brockton, where he was determined to be deceased several hours later. Several detectives from the Canton Police arrived on scene moments after the 911 call. They began to search within the snowbanks for any evidence, at which point they discovered a broken cocktail-style glass and multiple patches of red substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk County District Attorney's Office, specifically Sergeant Buchanan and Trooper Proctor, then arrived at the scene and began the process. They also spoke to several witnesses. Specifically, they spoke to Ms. Jennifer McCabe. She stated that the evening prior, she and some friends were at the Waterfall Bar located within the town of Canton. She stated she and her husband arrived there at approximately 9 p.m. At approximately 11 p.m., the victim and the defendant arrived at the Waterfall Bar together. She indicated to the troopers that the victim and the defendant had been in a dating relationship for the last 2 years, and that the defendant often stayed at the victim's house.
Lucci, thank you for becoming a new member. We will add $5 to the total. I think we're at like 20 right now. Thank you so much.
Most nights is what she described it as. She observed the defendant walk into the bar holding a glass cup from C.F. McCarthy's, which is a bar located across the streets from the Waterfall, with a clear liquid inside and what she believed to be a vodka soda drink. She observed the victim to be wearing a baseball hat, jeans, and sneakers. The victim and defendant had been at C.F. McCarthy's across the street before coming to the Waterfall Bar, as I stated. She stated that the victim and defendant appeared to be in a good mood and not observe any arguing amongst the two. Described the atmosphere within the bar as friendly amongst the patrons. She indicated as the bar began to close down, everyone was invited back to that residence on Fairview Road. She observed the defendant and the victim leave the Waterfall Bar together. As the group was exiting, the victim texted Ms. McCabe, where to, at 12:14 a.m. She replied with the address on Fairview Road. At 12:18, 4 minutes later, the victim called her to ask where specifically the house was located on Fairview Road. While inside the residence, she observed a black SUV arrive in front of the residence on Fairview Road. She observed this from the front door. She texted the victim at 12:31 a.m., hello, and at 12:40 a.m. texted, pull up behind me. She then observed the black SUV move from the initial place the vehicle stopped on the street near the driveway and then proceeds to the left side of the property.
Exonerate, thank you so much for becoming a new member. I appreciate that. $5. 25% of your $5 go back to Karen Reed. Sarah, wow, thank you so much. 10 gifted memberships. Welcome aboard new members. So that's $50. And we'll add that to the total. And then Gwen with a $20 super sticker. I really super appreciate that. And this is crazy. This is what I mean. Like, people haven't seen this. And you're going to hear I mean, this is the first time this was, brought out in public, said in public. And it's funny how the story changes, how their story changes multiple times through all these hearings. All right, let's keep playing.
At 12:45 a.m., she texted the victim hello again, and then observed the black SUV drive away. She stated that they discovered the victim in the area where she last observed the SUV on the left side of the property, as facing from the street. And at approximately 4:53 a.m., she received a phone call from the defendant looking for the victim. She indicated that the defendant was distraught and drove to her house. The defendant indicated to Ms. McCabe that she last remembered seeing the victim at the Waterfall Bar. Ms. McCabe then informed the defendant that she observed the victim and her leave the bar together. Ms. McCabe then drove the defendant's vehicle from her house back to the victim's because the defendant was too hysterical to drive, and had the other friend, Ms. Carrie Roberts, follow them. While driving to the victim's house, the defendant stated to Ms. McCabe, "Could I have hit him? Did I hit him?" Ms. McCabe stated that the defendant told her about a cracked taillight on her vehicle. Once they arrived at the victim's home.
Yeah, it's funny too, because I'm glad that you brought that up, and that's something that just jarred my mind. In Paul O'Keefe's recent interview, he said, "Oh, when they were up there, and they were, Yannetti made that statement that, Karen, if Karen hit him, she didn't mean to hit him." I mean, you got to think about it. This case is like days old when David Yannetti takes this on. He hasn't even looked at all of the evidence yet, and simply making just a statement, a quick statement. So obviously, when you get more time to look at things and look at the broader scope of what went on in this case, it starts to kind of mold and shape what went on. So I thought that was pretty funny that Paul brought that out. I mean, literally, he's defending his client at this point. It's new. He's not even sure yet. He hasn't even looked at the evidence. And then finally, when they can dig into it, they went, this is what went on. This is what went on. So, your first perception is a lot different when you actually get the evidence in front of you to look through. So we had to say something at that point. Let's see this. $5. Brendan, thank you so much for gifting the membership. I appreciate that. All right, let's keep playing through.
The defendant had Ms. McCabe looked at that same cracked taillight.
Yeah, that's right.
Ms. McCabe described the passenger side right rear taillight as cracked. They then both entered Ms. Roberts' vehicle to look for the victim, with the defendant seated in the back as Ms. Roberts drove, and Ms. McCabe was seated in the front passenger seat. Ms. McCabe stated that they turned on Fairview Road from Chapman Street. At the time, it was snowing heavily, creating poor visibility. Ms. McCabe stated that just prior to the residence on Fairview Road, there was a cluster of trees, and immediately the defendant stated that she saw the victim. Ms. McCabe and Ms. Roberts were not able to see the victim and were initially confused by the defendant's statement. Ms. McCabe stated that Ms. Roberts began wiping snow off of the victim as the defendant laid on top of him for warmth and then began CPR. The troopers then proceeded to the Good Samaritan Hospital to view the victim. They observed approximately 6 bloodied lacerations varying in length on his right arm, the cuts extending from his forearm to his bicep. Both of the victim's eyes were swollen shut and black and blue. They observed a cut to the right eyelid area of the victim, observed his clothing to be blue jeans, an orange T-shirt, a long sleeve shirt, and boxer shorts that were saturated with blood and vomit. They observed one black Nike sneaker with a white Nike logo on the sides belonging to the victim.
Yeah, Wick, good point. $10. So sounds like more like a trial than an arraignment. Absolutely. That's a great point. It does. Sounds like it basically sounds like the bullshit that we heard on day one during the trial. It's the same thing.
On the 31st, the troopers attended the autopsy of Mr. O'Keefe at the Office of the Chief Medical Examiner. The doctor.
Oh, by the way, let everybody know my new lens just got delivered today. I'm hoping to get that over maybe tomorrow or sometime this week. I was talking about, and hang on, I'll show you kind of what, if you haven't seen, check this out. You gotta check this out. Hang on. So everybody was asking about an overhead shot when I have a guest in the studio and it would make it look like, we're having more of a conversation. So let me do this. I'm going to show you what I've been working on. But see, the thing is, I got a 16 millimeter lens right now, and I needed like a 13, and my lens came in today. So I'm going to get that switch, but check this out. And I'll bring that back up in a second, but I'll show you if you haven't seen it. This is what it's going to look like when, obviously it's not all lit up right now, but let me bring this in. So now when someone's here, they'll be right there, and all these lights will be moved out of the way at some point. And now you can actually see the guest when they sit down. So it look like we're actually having a natural conversation. There won't be a spot camera on them, but at least you can see the guest. So once I get a 13 millimeter lens, that'll open up this area a lot more, and you'll be able to see the full guest when they're sitting there. So I thought like I'll just do the single spot on me, and then you can see us having a conversation. So that's what I've been working on in the studio here. I like it. I think it's a cool view. And, once I get the wider lens, it's going to be much better. But it was really difficult to figure out how the hell do I shoot this? Because I'm only in a 12 by 12 room. So how do I shoot it? And I like the overhead look. It's a lot better. And then, it will actually look like we're sitting with each other. But this is the command center here. If you all look, this is, my computer screen's in front of me, and everything around me. But all these lights will get pulled out of here. I'll probably just end up using ring lights. So, all right, enough of that. Let's pull up the stream and go back to the arraignment here. Let me drop that camera. There we go. All right, back to the arraignment. Here we go.
Performed the autopsy.
Camera off. I'll be right back.
Below, advised of several abrasions to the right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of his nose, approximately 2-inch laceration to the back of his head, multiple skull fractures that resulted in bleeding. And further advised that the victim's pancreas was a dark red color, indicating that hypothermia was
on the arraignment February 2nd, 2022.
On January 29th, the troopers conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, "John's dead. Terry, I wonder if he's dead. It's snowing. He got hit by a plow."
Wait a minute. Let's go back there. Knowing you get hit by a plow. Let's go back. I want to hear a little bit more of that. Let's check this out.
To his death. On January 29th, the troopers conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, "John's dead. Terry, I wonder if he's dead. It's snowing. He got hit by a plow." The troopers also on the 29th proceeded to the defendant's parents' home in Dighton, Massachusetts, where they located the involved vehicle, which is a 2021 black Lexus SUV. That vehicle was ultimately seized and taken back to the Canton Police Department, where it was processed by various factions of the state police. Their observations of that black SUV indicated a crack in the right rear taillight. They did speak with the defendant. She indicated that she had met with the victim at the C.F. McCarthy's bar in Canton at approximately 9 p.m. on the 29th, that he was there with several.
Farina, thank you so much for the 25 on Cash App. Yeah, crack, right? Farina, thank you so much for the 25 on Cash App. I appreciate that. And yeah, crack. Crack, not shattered, crack, right. Let's go back and listen to it again. See, I'm telling you. When you go back and listen to all this stuff and see what the initial charges were and how the Commonwealth was laying this out, it's a lot different by the time they got to trial, right? All right, here we go. We'll play this again.
They did speak with the defendant. She indicated that she had met with the victim at the C.F. McCarthy's bar in Canton at approximately 9 p.m. on the 29th, that he was there with several friends prior to her arrival. She stated the victim was consuming beer and she was drinking vodka sodas. She described the glassware she was drinking out of as a vase style. She stated she and the victim left C.F. McCarthy's and went to the waterfall, that she did not She indicated to the troopers that she did not leave C.F. McCarthy's or enter the Waterfall bar with a glass or drink. She stated that she and the victim were at the waterfall for approximately 1 hour. During that time, there were no altercations and no injuries, no cuts or abrasions that occurred with the victim. She indicated that they left the waterfall and were invited to the house on Fairview Road. She stated that she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated that she dropped the victim off. She made a 3-point turn in the street and left. Did not see the victim enter the house. She indicated that she first observed a broken taillight in the morning and did not know how she broke it the previous evening. She indicated that she discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen, and blood coming from his nose and mouth, and that she provided mouth-to-mouth upon her arrival. Further indicated that throughout the night she had been calling and texting the victim numerous times with no response. Officers also interviewed several first responders, including a firefighter paramedic from the town of Canton, indicated that she arrived on scene, observed the victim's condition, went to speak to the defendant in regard to any sort of prior medical issues or causality of the injuries that she observed to his face. To which the defendant then made several statements to her, indicating, "I hit him, I hit him, I hit him, I hit him." As I mentioned, the black Lexus SUV was seized. There were fragments of broken glass that were observed on the rear bump of the vehicle. The rear right passenger side taillight was shattered, pieces missing from the red and clear areas. On the right side of the rear tailgate, a deep scratch and minor dent was observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed in one area where paint was chipped off. Troopers from the Collision Analysis and Reconstruction section of the State Police performed several tests on the vehicle, including a rapid acceleration forward.
Oh my God. Caveman $5 says, "Where all the lies continue. Oh my God, Lally sounds like a robot. Poor Karen had to listen to him for 2.5 years. And we had to listen to him for fucking 2.5 years. It's insane. All right, let's keep getting through this.
Reverse,
and we'll get the action here to defense in a couple minutes here.
System. They also implemented the use of a training figure resembling a human approximately 6 feet in height that was placed behind this Lexus. It was operated by members of the CARS unit.
Why didn't we ever see that video?
And documented with video.
Why didn't we ever see that video?
Was placed in reverse and started to travel towards said training figure. The rear view camera on the vehicle was operating properly, providing a 180-degree visual. And as the Lexus traveled closer to the figure, both auditory and visual cues began to sound off within the vehicle, indicating an obstruction to the rear. In addition, on the 29th, the Massachusetts Special Emergency Response Team, or CERT, was activated to assist in searching for potential evidence outside of the residence. Standing on the street, looking to the left of the property, there was a fire hydrant located there. In that area, they located a black Nike sneaker with a white Nike logo along the side, matching that found on the victim's body. In the area of the street where the victim was recovered. In addition, in that same area, they located 2 red plastic pieces of a taillight consistent with the missing pieces from Miss Reed's black Lexus SUV, as well as 1 piece of a clear plastic piece of a taillight located in the same area, also consistent with the broken taillight on the Lexus SUV.
Video.
Your Honor, with the nature and circumstances of those facts, as well as the potential penalty the defendant faces on these charges, the Commonwealth is requesting that the court set a $50,000 cash bail with the conditions as outlined previously.
Thank you, Mr. Lally.
Thank you.
Mr. Yannetti, and if you would, go right to the mic.
Thank you, Your Honor. Good morning again, Your Honor. David Yannetti for Karen Reed. Judge, my client is 41 years old with no criminal record. My client grew up in Taunton, Massachusetts. She's a graduate of Coyle Cassidy High School in 1998. And when it came time to go to college...
Can you imagine what's going through your head at this point if you're Karen? Like, oh my God, I didn't do this. They're saying all these things that I didn't do. What do I do now? I mean, that's the look on her face. That's the look on her face. I mean, it's just surreal at this point.
She stayed in Massachusetts and went to Bentley College. She graduated with a Bachelor of Science in Finance in 2003. and since then has worked in the financial sector. And in fact, she's been at a very large,
I agree, Maslin.
well-known financial company since 2007, where she's currently an equity analyst. In addition, she's an adjunct professor at a Massachusetts university as well, and she's been there since 2008. In addition, Judge, my client suffers from a host of medical issues. From the time that she was 25, she's had multiple serious illnesses diagnosed, beginning in 2005 with colitis, which ultimately led to her colon being completely removed in 2009. She's been in pain for a number of years, and eventually also was diagnosed with MS as well in 2013. Continued to have digestion issues and bowel issues. And this past summer, my client unfortunately was diagnosed with having a brain tumor as a result of migraines that she had never had before. There is still no answer regarding whether that brain tumor is cancerous or not. And I bring this up not for the purpose of evoking any sympathy, but to focus on what the court's inquiry is here today. The inquiry is, what is the likelihood that my client will appear in court for her trial? Does bail need to be set to assure her appearance at trial? And if so, how much bail should be set? Her roots are here. She was born here, she went to school here, she went to college here, and her doctors are here. And in addition, her family is here. Her parents are present in the courtroom, her brother and her sister-in-law are present in the courtroom. And Your Honor, just so the court's aware, I'd like to have a letter that I sent to the Norfolk County District Attorney's Office this weekend. It was faxed on Saturday, where I promised that my client would appear if they just called me. All they had to do was notify me, and I wrote right in the letter that she would report to any police barracks or police station or courthouse to which they directed me. They ignored that and instead got an arrest warrant for my client. However, she knew. She had hired an attorney since January 30th, this Saturday, because the police had come and they had taken her phone and they had taken her car. She knew that they were considering her a suspect, rightly or wrongly. And what did she do? They arrested her at the very address that I included in my letter to the Commonwealth, which the Commonwealth ignored. This is relevant, I would assert, Judge, regarding whether she is a flight risk. I think that it doesn't really pass the straight face test. She is not going anywhere. She didn't go anywhere. I frankly don't think they've overcome the presumption of personal recognizance in this case. With regard to the facts of the case, Judge, I've read the affidavit that the prosecution has now read. Manslaughter is a tremendous reach in this case. I don't see any criminal intent that would justify manslaughter in that affidavit. And there's a reason for that, because there was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love, somebody with whom she essentially lived with. And by the way, the police have her phone. At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend, wondering where he is, why he hasn't come home.
So here's the thing, and I'm going to stop this really quick. And this is where, I know all of you understand this. All of you here are Free Karen Read supporters and supporters of Karen Read. And I just go back to logic. It's simple logic in this case. If someone wants someone dead, why are they doing the following? Making multiple phone calls, making multiple text messages to find out where you are, calling people that you were with the night before to ask, do you know anything? Showing up on scene and providing life-saving procedures, CPR. To me, it's pretty clear If Karen Reed wanted John O'Keefe dead, why would she have done all those things? Why would she have traveled back to 34 Fairview, the last place that she dropped him off, and watched him walk in that house, to go back and find him, to start at that point? She wouldn't care if she wanted him dead. She would have slept the day away. She would have left. She would have went somewhere else. But obviously, she didn't have anything to do with John's death. That's why she did all these things.
Home and getting annoyed with him because his niece, of whom he was a guardian, had to go to bed without saying goodnight to him. She had no idea that he was deceased or that anything had happened. At 5:30 in the morning, she's placing probably about 10 calls to him for the same reason, before she now knows something's has to be wrong, because he never stayed out at night without her. If they were ever out at night, they were always together. He had never not come home. And that's when she calls her girlfriend and goes back to the scene and sees this horrific scene. So, Your Honor, this is a defensible case. There is no reason for her to run. She's done the opposite. She hired an attorney almost right away. And by the way, there will be substantial issues regarding a motion to suppress statements here. As I put in the letter, and I'd like to, again, have this marked as an exhibit for the bail hearing. As I put in the letter, the police multiple times violated her.
Mr. Lally, any objection to the letter committee?
No objection.
All right, thank you. Acceptable, Mark.
Thank you very much.
Go ahead.
Yeah, the police violated her right to counsel multiple times, Your Honor, and we'll be able to show that at a motion to suppress hearing. Their case essentially comes down to statements, because there's no eyewitnesses. There doesn't appear as though there's any video evidence. There's nothing to indicate
No video
what
evidence.
actually
Wow.
happened on the day in question. And I think the police sort of acting out of desperation, realizing that they didn't really have much of a case, needed some type of confession from her. She did not give it to them, and yet they questioned her despite the fact that she asked for a lawyer. So the bottom line, Judge, is it's a defensible case. She's not a flight risk. And recognizing the seriousness of the charges, I won't ask for personal recognizance, but I would assert to the court, this case does not justify more than a $5,000 cash bail.
Thank you. My guess is you have no objection to the proposed conditions.
Well, the only condition that I would ask to be heard on, Your Honor, is this condition that she not drive. The police and the district attorney's office and the registry of motor vehicles have options to address that issue if they believe that she's an unsafe driver. And I would ask the court not to get involved with that issue.
Thank you. All right, with regard to the conditions, she is ordered not to drive unless licensed or permitted by the Massachusetts Registry of Motor Vehicles. And I appreciate your argument, Mr. Yannetti, but due to the nature and the circumstances of the offenses charged, specifically 1 and 3, and the potential penalty, I know what your letter says, you're the lawyer, but she has plenty of reason to flee. Given the potential penalty, I'm opposing the $50,000 cash. Yes, on the motion, I have Mr. Lally, a motion for preservation of evidence. Have you had a chance?
50,000. What is it? You just pay 10%, so that'd be $5,000. If I'm right on that, I don't know what percentage you have to pay in Massachusetts, because I don't think you have to pay the whole 50,000. Maybe someone can help me here if they know about bail. Is it $5,000? Oh, my voice cracked. Oh. Is it it's $5,000, right? She would have to pay to get out. Is it 10%? Let me know. Yeah, flight risk. That's insane. It's 10%. Yeah, I thought it was. Yeah, I didn't know if Massachusetts was different, but it's, yeah, the general 10%. 10% with a bondsman. Yep. Okay. You have flight risk. That's so funny. All right, let's keep playing.
Chance to review it.
I have, yes, sir.
Do you have any objection to it?
I do not, Your Honor.
All right, thank you. I'll allow that.
15%.
Can I have a date, please?
And just to be clear for the record, with regard to that motion being allowed, Judge, I would ask that it be effective with the court's signature with regard to previous reports that have been filed and anything that's been gathered, and certainly going forward. There should be no destruction of notes going forward in this investigation.
Well, it speaks for itself.
Yes.
It's a preservation of evidence. I just signed it. It's 10:22 a.m. on February 2nd. That's when it's effective.
Thank you very much, Ron. In terms of the next day, could I have March 1st, Judge?
Sure. Mr. Lally, that work for you?
It's full amount. Really?
If not, we'll go to.
She had to pay the 50,000. 50,000. Wow. Oh yeah, that's right. Because they have $80,000 of her money. That's right. Because when they upcharged, so you are right. She had to pay the 80,000. Wow.
One other thing.
If possible, yeah. If
You're right.
possible,
Forgot
the
about that.
3rd or the 4th, if that's.
Well, I mean, she is entitled to be brought back within 30 days.
Sure.
Sorry about that.
But
That was my
Mr.
mistake.
Lally, if I may, Mr. Lally, you can have a 9 o'clock, 11 o'clock, or 2 o'clock call.
Thank you.
Nicole.
11 o'clock on the 1st is fine.
All right. That work, Ms. Sina?
Just sharing.
Thank you.
Mr. Docket 22 CR 66, court is setting bail in the amount of $50,000 cash to ensure your presence back here March 1st for a probable cause hearing. You have a right to petition the Superior Court for a review of that bail. Conditions of this case are that you stay away and have
Yeah,
no
it's
contact with the
80K
victim's family,
overall.
stay away from the victim's residence, and do not drive a motor vehicle unless permitted to by the Registry of Motor Vehicles. You'll need to sign those conditions before you're transported today.
Thank you, Ron.
Thank you.
Thank you, Ron. Thank you, Madam Clerk.
Deputy Mayor.
Okay.
All right. Court stands in recess. I'm gonna ask
Now remember, Karen at this point has zero support. Turtle Boy didn't drop the first article for, let's see, February, March, April, for like another 3 months. So she had no support at this point. There was no one showing up at her hearings. There's no one showing up. She's fighting this all on her own right now, just her and her attorneys and her family. And then once that article drops in April and Aiden kicks this all off, that's when it starts to build. The Free Karen Read movement starts to build. Man, thank God for him. Thank God for him. This case would have been completely different. Okay, let's go to that May 3rd hearing, which I think is, in my opinion, one of the most important. Let me bring that over. All right, let's kick this off. Another bad audio, but I'll try to boost it as best as I can. This one's only about an hour. Again, I just want to remind everybody, any donation that comes in tonight, 25% of your donation will get kicked back to Karen Read's defense fund to help her fight back this the evil empire. And I think we're just over $100 right now, so 25% of that. And I want to try to at least get to $50 tonight to kick back to Karen Read's defense. All right, let's keep playing here. And if you want anything highlighted and brought up, anything over a $5 super chat, we'll bring it up, we'll read it. And here we are. So it's a very important hearing here. This is May 3rd, 2023. And this one is super important. All right, here we go.
Good afternoon, Your Honor, Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson.
I'll turn it up if you need to hear it a little lot better. It's hard to hear.
Here for the Rule 17
Here we go.
motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd
Hey,
like
Nick, what's
to be
going on?
heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases.
Give me a
And
second, be right
I
back.
would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence.
All right, let me read this. As far as the volume, I have no control over it. So you're going to have to turn it up on your end. This is piss poor volume inside the courtroom. So I'm trying to do the best to boost it as much as I can without blowing anybody's ears out. So that's going to be on your end because it is up all the way. And I have a little bit of a booster on it too that I've turned up. I'll turn it up a little bit better. Jamie, $10. Thank you. Oh, wow. Did not know that. Here in New Orleans, they have a bondsman everywhere. Don't ask how I know. Laugh out loud. No, seriously. I know because I bailed a few people out in my time. Thanks for sharing that. I appreciate that. 25% of your donation will get back to Karen Reed's Defense Fund. Lady, thank you so much for becoming a new YouTube member. We'll add $5 to the total as well. And I think I had a PayPal come through too. And let me just read that and then we'll kick this back off. Let me see. Wow, big donation. Mary, thank you so much for the $50 donation. So we'll add that to the total. I really appreciate that, Mary. Thanks for supporting the channel and thank you supporting Karen Reed. Nick Rocco in the chat saying almost $40,000 in popcorn sales. Make sure to get your popcorn at Nick's link. Wow. $40,000. Nick, what is this, like just a week? It's been like a week, right? $40,000. I wish I had that much power to raise that amount of money. You guys are amazing. You're an amazing fundraiser. That's fantastic. Has this been like just only like a week, right, Nick? 4 day run. It only runs for 4 days. Wow. When is it ending? So we can get people over there. Kelly Reed said 3 days. 3 days. Wow. That's amazing. And today is the end of day 3. So it's going to run one more day. So please, if you can, click on the link. Click on the link and let's get Karen some money. And of course, tonight we'll donate back to Karen as well, too. Try to do every little bit we can here to help. That's what it's all about, helping out. All right, let's keep playing. And Karen gets 50% of all sales. That's awesome. That's so cool. All right, let's keep playing through here. Here we go.
For our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in 2 prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from 2 coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that this case has been pending in this court, we've continually asked for access to this.
I got to pause this again real quick. Nick says, next time I'm going to change my name to Nick Reed and maybe I'll get many sales. That's great. I like that, Nick. Sharon, thank you so much for becoming a new member. I appreciate that. Thank you for your support. We'll add $5 to the total. I think we're at about 185. Rogue, did you get the $50 on PayPal? Did you hear that? I just want to make sure that went through as well, too. All right, let's keep
same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In
Well,
fact,
I think the biggest reason it was brought up is because if you went back and listened, Karen said that she was having stomach issues the night at the bar, and that's why she didn't want to stay at 34 Fairview. So she dropped John off, watched John walk into the house, and she went home because she wasn't feeling well. That's why that got brought into this, and that's why it became relevant. And listen, I don't want to hash over Karen's health issues. That's not my business. I don't care to speak about it, but that's why it was brought up in the trial.
February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, have the response from the Commonwealth was that they would be tested soon. The prosecutor had represented
Kurt Beef, $10. So thank you for taking the time, and thank you for taking the time in thereling the story. Keep up the fighter. Thank you so much, Kurt. I appreciate that. Thank you. So we'll add $10 to the total. All right, let's keep going here.
within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton.
All right, let's do that real quick for Nick. I want to show these. This is actually really great. Let me pull these up. This is inside the war room. Oh, wrong screen. Sorry. I'm going to do it again. See this here? Just kind of blowing off some steam, some ping pong. This was some more war room footage here. Coming together as the beginning. This is the documentary that's being shot. Another great picture of Karen and her brother. More war room. I want to make sure people understand that when court ended for the day, they went back and worked. They were always working. So keep that in mind. Always doing something. Yeah, that's a great view, right? Look at that. That's a good shot too. Look at it. Alan Jackson with the veiny arm. Look at that. Jacked. I need to get on his. I love this photo. This is great. I love this photo. Liza and Karen together. And I have heard they got very close through this process. And where's my favorite? That's the photo I took inside the I took a photo like this too, inside where Karen was deliberating. These are great. Let's see. That's a good one too. Karen's papa. Love this photo. Love this photo. Love it, love it, love it. If you all don't know, because the artist never got back to me at the church that day. I gave her my number. I said, hey, get back to me. Well, I went out and did this. I actually blew it up and I got it in my studio. So I blew up the photo. And I got it right over here on this wall over here. And I actually framed this, but I got to fix the frame. That one's on my desk. And then I got to fix this frame, though. I got this one blown up. And that was the one when I got invited in court that day. So I got that one, too. Yeah, that's the Free Karen Reed Instagram page, Nick. I can drop the link in there if you all want to get on that. Let me do this. I'll drop it in the chat. I'll go over there and subscribe. It's been getting updated a lot. So, yeah. All right, let's get back to the hearing. Appreciate y'all being
Library
here.
video, this court should know, we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by.
Hopefully, my dream is one day, if I ever get the opportunity to speak with Karen a little bit longer, to actually have her sign that photo. I'd love to have that large photo signed by her. So maybe someday, that'd be really nice to have that in the studio. Really cool. All right, let's hear David fighting for Karen Reed.
At that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage.
There was a lot. You got to understand, there's a lot of people at this point. There's a lot of support now. This is almost 15 months after she had been initially arraigned. So Turtle Boy's reporting and the support has built. There's no seats. So that's what you got here. Yeah, super overflow of people. You gotta think this is 15 months in now. So it's already built.
Floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. The Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID and that password. We cannot rely on Trooper Michael Proctor conflicted Michael Proctor to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th. Those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review. So once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the district attorney's office or the state police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle.
I can't with the hair. It's just unbelievable. Lisa, thank you so much for the $10. Thank you for replaying this for us and hashtag free Karen Read. Not a problem. Not a problem. Like I said, there's a lot of people that have just come in new to the channel or new to this case. You know, maybe they just saw the trial, but they didn't see the pretrial hearings. And it's important to watch and listen to these because it kind of give you a perspective of where the Commonwealth was coming in going into trial and how much Team Read was really fighting for Karen and really putting that case out there in her defense. Crash Daddy, thank you so much for becoming a new member. We're going to add the $10 and another $5 to the total. I super appreciate that. All right, let's keep going.
It was taken to the lab, and I was informed by the lab that any testing of that DNA for comparative purposes to Mr. O'Keefe would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails. I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video.
Oh, I've had Better on twice now. I actually just did a show with him. When did I do that show with him? A couple of days ago. You should go back and watch it. You can look for it on my homepage. We just did one 3 nights ago. Friday night we did it. Go back and watch it. And then I had him on before that too. There's two videos up, 2 lives up with Bettero. He's great. I think he was on TV's channel last night or the night before, Thursday night. When did he jump on? I don't know. I honestly, I don't have a lot of time to watch other creators, but I know he jumped up with Aiden the other day. So, all right, let's keep going here.
Was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case.
Which
the children
is true.
The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters.
Which is a lie.
That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the district attorney's office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence.
Jamie, thank you for becoming a new member. New member will add $5 to the total, and 25% of all of the donations that come in tonight will get kicked back to Karen Reed's Defense Fund. Okay, let's keep playing here.
It was then archived on our system. Recently, we reached out and spoke to the IT director of the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it. Essentially, it won't open.
So the
link expired within 60 days, if not 30 days of being shared with our office. But the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archive within our system, was then placed onto a disk, and what's on the disk, what's been provided to council, is what we received.
Thank you, Rogue.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
All right, let's hear Alan Jackson in normal speed here. Party on, Wayne. Party on, Garth. Every time I see Bev, I just think Wayne's World. Wayne's World. Party on. Party time. Excellent.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue. That Rule 17 motion, we're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are essential to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number 1, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found.
I love this. And that's it.
He
That's
had
the
this
first time we saw this.
set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm.
Beck, thank you so much for watching in Australia. There's a $3 Aussie. Thank you. She says, I'm outraged. I'm outraged from Australia. Thanks for checking in. I appreciate it.
Arm only, from mid biceps to mid forearm and no other place. For instance, mid biceps and mid forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to.
Amber, thank you so much. $20 says, thank you for your hard work. In Houston and after Monday's hurricane, it's been me and 2 toddlers while my husband works 16 plus hours a day for the electric company. Wow. Y'all count as my adult interaction. Got my popcorn from Kelly. I don't know if Nick is still here, but we had a Kelly buyer. But it all is on good. It's all in good fun. And I love all the little memes they've been doing in the videos, and they've been kind of battling it out and back and forth. Paul had a cease and desist order or something like that this morning, which was hilarious. It's all good fun. It's really, really good stuff. Dr. Jen, thank you so much. $20 says the injuries do not add up. Maybe Microdots will do a video on this from Boston. Thank you so much. I appreciate that. Maybe.
The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Albans?
Dun, dun,
Which is
dun.
exactly where Officer John O'Keefe was found dead. In February of 2017,
Let me just pull this up. Wow. Name. Thank you. $50. Time to donate to a good journalist. Thanks. I appreciate that. And I appreciate the compliment. I just want to make sure that everybody understands, what I'm doing. I'm just a guy in a studio making some videos. I have an actual website that I'm working on, and I won't do the full commitment to journalist until my website and my print is up. But I guess you can kind of call this some type of journal. I don't know what the hell I'm doing. I'm just trying to help someone. That's all I want to do. I'm just trying to help someone get out of this stupid, sticky situation that they're involved in. And, it just, this just gives me a platform to come here and spend my time with all of you. And it's, a common interest in fighting for truth and justice, getting someone out of this stupid, ridiculous situation. And like, we've always said, Karen Read could be any of us. And if we were ever in this situation, I would hope that someone would fight for us too. You need to fight back. You need to fight back in these situations. And I am so glad that she has not folded once. She hasn't faltered once. In all of the public appearances that she's been in and out of court, the photos that we've seen, she has not stopped fighting once. There's been no indication of that at all. And to have that amount of strength and spirit and believing in yourself and not fall, I don't think I could do it. And believe me, behind the scenes, we don't know what happens in Karen Read's life. We only see what's out there in the public and during these these court appearances. There's probably nights she goes home and cries her fucking eyes out, maybe almost every night. But to have that strength is just unbelievable. You cannot beat her down. She's going to win. She's going to get out of this free and clear. And I will continue to fight for her until her name is free and clear. You got that. You can mark that down. I will not give up. And I know all of you won't give up. And I know her family won't give up. And the amazing people that have come in and done a lot of amazing things for her. Turtle Boy will not stop fighting for her. Nick Rocco will not stop fighting for her. All the amazing creators that have, that I align myself with, that have helped out and get Karen's message out there, they will not, stop fighting. So we are very privileged here, and I feel very privileged to be in the company of all of you and all the amazing people that I just spoke of. Keep up the fight. That's what we need to do. All right, let's get caught up on some of these supers. I appreciate it. Name, thank you so much for the 50. I appreciate that. Donna, thank you so much. $2 super sticker. Love it. Thank you. Let's see. Scooter, $5. Karen Read is not guilty, factually innocent. We all agree. Appreciate that. Karen, thank you. $10 Canadian. I Canadian peeps peeking in tonight. Watching from sunny, hot, southern Alberta, Canada. Sending prayers to Karen and her family. I too was diagnosed with MS in 2013. Well, thank you for sharing that, and thank you for your $10. And I hope that your MS is controllable and you can live a healthy life for the rest of your life. Thank you. Gene, $5 membership. Appreciate that. Welcome to the members. Jason, 10. YouTube won't let me mention last night. Karen Read is the victim of a corporate regime. Love that. When prosecution fails, they move to plan B and is nuts. Thank you for the 10. We have a $5 Aussie. Look at this. My Aussie's checking. Another Aussie here. Home watching while I work on this cold midday Monday. With the whole world watching now, this corruption needs to end. And I absolutely agree. Oh, Jamie, I thank you. Appreciate that. Like I said, I'm just some guy in a studio trying to fight for what's right. Thank you. All right, let's keep playing.
We know that the
Where it
Alberts
gets
had a
good.
dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks.
Let me just get this in really quick. A $5 donation. Jedi Jen, thank you so much through Buy Me a Coffee. I appreciate that. We'll add that to the total. All right,
That
let's go.
are heretofore and up to this date, today, completely unexplained by the Commonwealth.
Thank
By
you.
May of
Thank you.
2022,
Thank you.
Karen Reed's defense team starts asking questions about this animal,
Thank you.
about these injuries, about the dog, about what dog existed
Thank you.
at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly,
Yeah, I agree.
the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid
Oh,
of.
thank you.
And to date,
I appreciate
the
it.
Commonwealth has yet,
Thank you.
as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine, a large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, who would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death,
Excuse me.
the dog has been gotten rid of. got rid of the evidence in the basement,
Oh, I'm glad you're enjoying
got
it.
rid of the
Andy.
house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a grand jury, a federal grand jury, to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense, the tools that we need
Oh,
to
you're
fully
welcome,
investigate
Peggy.
this case.
Anytime.
We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something. And then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, that those summonses issue. The request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the.
Cutting them off again. Always cutting them off.
Thank you, Your Honor. Your Honor, first I would state it's an interesting sort of straw man argument.
Straw man.
As far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that, but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the records, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as it could shed light, or if true, this fact would undermine the prosecution's entire theory of the case. There have been a couple of theories that are stated within the context of counsel's motion. I can say for the record, those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could, and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame. As it's stated within the motion, it's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head, that there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take the then inferential lead to these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are then take the inferential lead that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
Oh, I remember this. This is not there was a issue with the court video. It'll pick back up here, but to give me a moment to pause here. Caveman, $5 says Lally's mouth is like road rash. The glass was not embedded, just sitting there. Okay, lies. Scott, checking in. What's going on, Scott? How are you? Hi, peeps. Long day. 2 standouts, Auburn, Mass. and Quincy, Mass. DA Meatball, Morrissey's neighborhood. Then out to dinner tonight. DA Meatball protest at NCDAO tomorrow. We ain't got no quit. Yes, I did advertise that at the beginning of the stream. Y'all can make it over there. 45 Shawmut. Is it street or Ave? In Canton. In Canton. All right.
Well, we've had an interrupt in the feed there from the courthouse at the Dedham Court, but we've been listening to attorneys talk about their motions in the case of Karen Read. Let's go back.
As far as how the medical professionals detail what those injuries are. In those medical records, what the personnel of Good Samaritan, the doctors and nurses who examined Mr. O'Keefe when he came into their facility, they described his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration, positive or surrounding soft tissue, swelling, positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observed that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction, the right blinker on and the left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle.
Wrong. Remember Ryan Higgins? A 6-foot dark figure came in the house. Remember?
Vehicle. And I'm a little confused just as far as counsel's statements, as far as the
Ooh, excuse me.
multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular.
The second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right, what's it for? The evidentiary hearing?
Yes.
All right, so do you plan on arguing your Rule 17 motion today or that day? Not
Let's see this. Athena, thank you so much for the 50 on Cash App. I appreciate that. My stream, of course, is having issues again. I thought we had all this ironed out, but if this continues, I'm definitely gonna. I just want to get a hard line in this room. I know it will fix everything. And I actually talked to my landlord about it the other day. He's such a great guy, and he's like, "We need to make it happen. Just let me know. We'll get it done." So, sorry about that. My stream bumped down a little bit. Hopefully, we captured the $50 that I just called out. Rogue. Hopefully, you got that. And thank you. I appreciate that. Okay. Yeah, my computer doesn't want to hear Lally's voice. All right, let's try to finish this up. We got about another 15 minutes, 20 minutes or so. We'll get this finished up, and we'll call this one a night. Thank you all for being here. Appreciate that. Take a second here to smash the like button. Let's get this stream out to other people to get them educated about what's going on in Karen Reed's case. And then, again, we have the hearing coming up on the 22nd. I cannot believe they're going to continue with this.
for today, unless there was any follow-up to Mr. Lally. I'm not going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house, with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten facially and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound
Thank you,
German
Allison.
Shepherd
Appreciate it. Thank you.
that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of it. So we know
Lori,
that-
thank you. Five gifted memberships. So that's $25. We'll add that to the total. I appreciate that. Thank you. Thank you so much. Welcome new members.
the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after 15, 16 months that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce.
I love Turtle Boy's face right there. Let's go back a little bit. Watch Aiden's face right here when he talks about being stabbed with a cocktail glass. Watch, he shakes his head and kind of laughs a little bit.
That somehow
Watch this.
John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce
I love that.
these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it in reverse,
I love
then
this,
hits him with the
Aiden.
car with her taillight in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and
talks like a duck, it's a
duck.
duck.
This looks like an animal attack because it is an animal attack. And it's at the same time, temporally at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth
thank you,
has
Mimi.
evidence that John O'Keefe went to the house. They haven't. They just sat on it for several years.
Yes,
or
a
for
lot of
several
time.
months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, you would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious.
Ooh, excuse me.
With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road as he.
If you all like this, I don't mind doing this, coming back and doing, some of these pretrial hearings. I wanted to do the one when the Fed letters were introduced. I think that's another good one. And if you want me to do these, we can do like movie night, and replay some of these if you're all interested in it. I don't mind doing it. I love going back and just listening to the defense team speak and how they molded their case and how they came out with all this evidence and presented it in front of the court. I think it's really good to hear this. I mean, they haven't changed. They have been so consistent through all of this. The only one that have changed is everybody on the Commonwealth side. The witnesses, Adam Lally has changed. They've changed everything that they've spoken about. They lied in proceedings and the grand jury testimony. And then they get in front and their stories change. mean, I definitely have no issue doing these until we get back to the 22nd. So, let's
approached the
go.
road. As he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said they observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her
Allison,
car,
thanks for the
and she sat
25.
there
I appreciate
alone.
it.
And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this? They can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner
Thanks
is in
for
a
being
fight?
here,
What does a
Karen.
German
Thank
Shepherd do when its owner is in a fight?
Thank you.
Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If, say, the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the record
Pilgrim Show, thanks for the $10. Appreciate that. So you're a humble dude. It's nice to see. I vote to review the pretrial videos since I came in late to the trial. Yeah, I don't have a problem doing that. We can go over these. Just kind of like a movie night. Let people review. We'll have some conversation. Raise some money for Karen. Absolutely. So, maybe we do this. We can continue doing these up until the 22nd. If you all want to be here for them, we'll do it. We'll do it. All right, we got about another, 12, 13, 14 minutes in here. We'll wrap this one up. It's getting late here on this Sunday night. I appreciate y'all being here. Hopefully try to get this banged out by 11. I'm tired. I worked all day. I want to go home, and I got a long day of work tomorrow. So, all right, let's keep playing through this. We'll get through it. Thank you all for being here. Thank you for raising money for Karen with about $112. With the $10 that came in, I'll round it to $115. That we'll kick back to Karen Reed's Defense Fund. And then tonight, what I'll do is immediately when the stream ends, I always go to the Defense Fund page, put the donation on there. We'll see LTL chat raiser, put the date, 7/14/24. I post the receipt on LTL Media Facebook page and on my community page. And then the ultimate Levette me, and just go right to the link and you'll see it right there on her defense page. All right, let's keep going.
don't exist,
Wrap it up.
because they just don't. They're too old. Then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have
thank
met
you,
the standards
Sarah.
of Lampron, all four standards of Lampron, and the summonses should issue. And also,
That'd be really great.
Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to, Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little
Sarah,
more when
thank
it comes
you.
to that subsequent
$50
Rule 17 motion.
added.
The Apple
Thank
Health
you.
data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data from Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location
Thank you,
information
Karen.
from Mr. O'Keefe's phone shows him en route to the house and not
Thank you.
arriving at the house until 12:24 a.m. So the information the council was relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to.
Thank you, Sharon. $5 Canadian.
Okay, I'll hear you.
So there were two motions to impound that the Commonwealth filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, really to both
Okay,
motions.
and those are impounded by statute.
Right. The other motion to impound that I filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Netti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is
Another
a specific
Vice, thank
reference
you.
made to the
$3
name of,
super sticker.
decedent's niece, which is
Excuse me.
strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Yannetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is out, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth.
Sharon, not
was
a
supposed to
problem.
have been
Thank you.
Requested to be
Thanks
impounded
for
at the
the
time it was
5.
filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just filed on behalf of his motion.
Right, we don't have-
When he was taking issue with the defendant who filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just
God,
address, the Commonwealth
we
had
like
filed
run
some
out
time
of there.
ago.
Fucking Bev. Is this hearing over? Oh my God. Like, give me a break. Let's go back. Listen to her.
This motion.
Right, and we don't have.
When he was taking issue with the
Is this hearing
with the
over?
defendant who filed.
Right.
Wants to run to a cottage.
Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So Is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction, a copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone.
I know you're on X. If you haven't subscribed over here on the YouTube channel, please do that. I love all my X people, but we'd love to get you over here on YouTube so you can partake. I mean, there's like over 900 people in this chat. You know, if you're not subscribed over here, come over here. LTL Media, just look it up. You can subscribe, and we'll get you over here in the chat too. There's a lot of people having some great conversation over here. All right, let's finish this up. We got about another 4 minutes. I think we're at about what? How much for? About 129 for Karen right now. I love it. Thank you all so much for your kind hearts in contributing, and we'll kick that 25% back. We'll make that donation. All right, 4 more minutes, and then we're going to wrap this sucker up.
Because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the
Aunt Deb, thanks for the $15 on Venmo.
Yes. I was the one to suggest that it be analyzed by the Attorney General's office,
Thank you.
Cyber Crimes Division. I thought that was
Aunt Deb says $15 says I'm giving you something to thanks for giving us something to watch, and I'm obsessed with the studio. Thank you. I can't wait. We got the new camera angle in here. I think it's going to bring a different dynamic. You know, I thought I was doing it the right way, but I listened to the audience. I said get a wider shot so when your guest comes in, and we'll get it ironed out in here. It's been a long road, a lot of stuff that I've never done before. I'm learning all this stuff, cameras and digitals and microphones and all that stuff. So I appreciate you. And I appreciate that. Wow. We just had a big donation come in. Wow. Jamie. Wow. Big donation, $100 donation. Thank you so much. Let's get the total. We're at 630. And 25% of that would be 157. So we'll round it up to 158. 158 right now. All right. We've got about another 3 minutes. 3 minutes, and then we're going to wrap this puppy up. Thank you, Jamie. I appreciate that. All right, let's go.
clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Motion's
Oh,
allowed
thank
by
you, Jenny.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive.
Thank you so much. I
testing
appreciate
thought-
that.
He argued that a while ago.
Okay, and was that acted upon by the court?
He
Thank
said he
you.
was waiting to hear back from you where we stood on that.
Right, so with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So, Mr. Lally, would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample will be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then I'll provide it to the lab. The lab will then contact their expert and schedule a time for the
Oh,
testing
thank
to be
you.
done.
Okay, we're happy to do that, but
Yeah,
my
we'll do
understanding
more
from
of
Mr.
these.
Lally's earlier argument is that only applies to the hair that was found on the car, that was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
I love that
So
roller.
exhaustive
Exhaustive testing
testing on
equals
any of those
inverted.
items,
Yes.
Mr.
Not that
Lally?
I'm aware of.
Okay, fine, yeah, so we'll sign regarding the hair. We're not concerned about that.
Okay, is that everything?
From the Commonwealth,
God,
yes.
I
she
believe
wants
so,
to
Judge.
go.
All right, thank you. We'll see you on the 25th.
Jesus. I mean, she couldn't get out of there quicker. Good Lord. Is that it? Is that all we got? I want to go home. Jeez, man. Slow down. This is important. This is someone's life. This is two people's lives. John O'Keefe and Karen Reed. Very, very important. Slow down. Jeez, man. Jeez. Let's see. So we are at I don't know. What are we at for a total? Rogue, give me the total. Some upcoming programming. So we'll continue to do these. I guess everybody's found some value in this. We'll play some of these pretrial hearings. I'll pick some of the ones that I felt were more important. I mean, not that they're not all important, but some of the ones that really stuck out to me. Also, let's see. I have a programming note. On Thursday, I'll be doing a pre-recorded video with caller Landry for his channel. So I'll be doing an interview about the Karen Reed case and trial and my experience with all of that. So look forward to that video. I just got to reach out to him and 100% confirm it. So we're at 157. I'll round it to 160. 160 for Karen. So I'll be doing that on Thursday. Probably come back tomorrow night, maybe, and do another pretrial hearing if that's what you all want to see. And then we'll just carry this out until the 22nd. Also have, let's see. Yeah, I know. Yeah, this is important, Scott. That's why I've been doing these. Also, what was I going to say? I also have some guests that should be coming on soon. We're trying to collaborate on a show together. It's going to be with the Sandra Birchmore group because I want to continue to do more of that. So we're working on getting a live together for that. I had someone very, very important reach out to me today, and I would love to get them in the studio. So if you are watching, I would love to get you in my studio because I think it would be a great thing to do here. So I'll be reaching back out to that big person soon and doing something with them. So I don't know. I think this is going to be it for tonight. It's late. We just passed 11:05 here on the East Coast. I appreciate you all coming to LTL Media and Let's Talk Live here on the channel. It's what we do. We talk live. I hate doing videos and recorded videos. I just got to hit live and go. And I love seeing the chat and interacting with all of you. Welcome in all new members, the subscribers, the people that watch these back on replay. It helps the channel. It really does help move this channel along. We just passed 32,000 subscribers the other day. It's unbelievable. It's unbelievable. We're getting closer to, we're 75% of the way to 50,000. Then once we get to 50,000, I'm going to go for that damn silver play button. I wonder if Aiden got his 100,000 yet. Let me go over and look because he is close. Did he get it yet? Because I want him to get that play button. He's at 95.8. It's probably killing him. It's probably killing him right now. So 100,000. Someone just hit 100,000. Who did I see hit 100,000 the other day? Aiden needs, let's see. Aiden needs, let me get my calculator out for my dumb math. He needs, what, less than 5,000? 5,000 more subscribers? Phew. Medkeith, thank you so much. Five memberships. That's $25. We'll add that in. And you also became a new member. No, I don't think it was Baker. It was someone on Uncivil Law's channel the other day. One of the law tubers that were on there. They just hit 100,000. That's really great. So that's another $30 we'll add to the total. Aiden's close. Aiden's really close. Oh, cool. Yeah, you have been here. 4,200. Yeah, 4,200. But I can't believe it. Who would have thought a year ago was at like 6,000 subscribers and just changed direction on the channel and started listening to the audience, dive into your metrics and do what the audience wants. So let me see. Let me get an updated total here. And then we're going to sign out here in a minute. And then I'll make that donation. 660 total. 25% of that kick to the Reed Defense Fund. 165 on the button. Love it. Love it, love it, love it. And maybe we'll come back tomorrow night and do another one of these pretrial hearings. I'll dig it out and do that. So thank you. Thank you all for being here. Thank you for supporting LTL Media. You know what's crazy? Real quick before I go off air. My landlord has a marquee. They're putting a brand new marquee in. And they're going to actually have all the business names at some point out there on the marquee. I'm like, what? My studio name? He's like, yeah, LTL Media is going to be out on the studio. I'm like, out on the marquee. I'm like, what? So when you drive by, you will see LTL Media on the marquee. That's fucking crazy. I never would have thought that. I never, ever would have thought that. Let me just acknowledge this. $5. Love your person, you're real. Thank you, Susie. Susie Irish, the 5. 665. I think it's still going to keep us at about what? Does it push us over the 170, closer to 170? We're at 166. I'll do 170 on that. 170 on that. So we'll drop the 170 to Karen Reed's Defense Fund tonight. Thank you all so much for helping me raise awareness, raising some funds. I love doing this and kicking back to the Reed Defense Fund. So it's nice to be back in that mode and being able to do that here. And thank you. I appreciate it. All right. I'm going to hit the outro. Everybody have an amazing Sunday night. Get some rest. Possibly going to be back to Aiden got hit hard with subscribers and politics last night. You know what? I did a political show last night too. I mean, listen, it's the reality of the situation. It's a historic moment in our country. You know, I talked about this at the beginning that I would not want to see any political candidate from either side have to go through what Donald Trump went through yesterday. That should not be happening in our country. Right now, we all need to stand together in unity and as Americans, because we're not a third world country. Our politicians should not be having attempts on their lives or even being assassinated. That should not be something that's celebrated in this country. And I saw some really disgusting videos out there because I would be saying the same thing for Biden. You know, and I'm not even a Biden supporter, but I would cover it the same way if this even happened to Joe Biden. I don't want anything to happen to anybody. We have a voting system to vote in November. That is a system that we have put in place to run this country. And every 4 years, it's your God-given right to get out to those polls and vote for who you want in office. That is your choice. There should never be political violence in this country against any of our politicians, no matter how much you might like them or hate them. It is their right to run for office. If you want to battle with words, that's fine. But picking up a gun and trying to vote that way is not the right way to do it. And it needs to be condemned, and it should never, ever, ever happen in this country again. All right, with that, my friends, I leave you with that thought tonight. I love all of you, and you all have a great night, and I will see you possibly back tomorrow night. If I'm back, I will make the announcement. Talk to y'all soon. Everybody have a great night. Thank you for everything. I'll get that donation up. Thank you. Good night.